Good afternoon, all. Today we are gathered here for webinar on intellectual property rights on the celebration of World Intellectual Property Day. It's my immense pleasure to introduce today's guest, Mrs. Saili Bidwai Madam, as an eminent speaker. She is working as a professor at MIT Academy of Engineering, Alandi, Pune. Currently, she is pursuing PhD from Vishveshwarya Technical University, Belgaum. She is having 15 years of academic experience, including 3 years in IPR. She had carried out number of expert talks, expert sessions for students and staff also. She is having 9 Scopus Index journal and 12 conference publication with her. She is also awarded with Distinguished Associate Professor by Computer Society of India for successfully demonstrating innovative and outstanding teaching methodology. So I heartily welcome Saili Madam in today's webinar. Thank you. Now I request to Dean of R&D to address us.
Am I audible? Hello, am I audible?
Yes, sir.
Okay. Good afternoon, everybody. Today's eminent speaker, respected Professor Saili Bidwai Madam. The eminent personalities present and our Honorable Trustee Sri Rohanji Paricharak Malak, respected Principal of the Karma Yoga Institute of Technology, Honorable Dr. S.P. Patil, Vice Principal Professor Mudagaonkar, all head of departments, deans, and beloved student friends. So today we are going to enjoy 1 hour webinar on this world on occasion of World Intellectual Property Day. and the eminent speaker is Professor Saili Bidwai. So first of all, I want to thank you, madam, for giving this opportunity to the students from Karma Yoga Institute. We also have little background for IPR. Few of our students are also working on good projects. Many of our faculty members are pursuing PhD program, and in couple of years they will get degree also awarded. As far as this IPR is concerned, few of us have already got published the patent on respected areas. One second in ENTC department, Professor Lambe, Professor Joshi, and also along with Dr. S.P. Patil, they got this patent in the pipeline, yet not granted. So we are expecting more and more patents from faculty members as well as students of Karma Yoga Institute of Technology. So regarding this, today Madam is going to guide us how to apply for the patent Form 1, Form 2, Form 5, Form 9, Form 18, Form 18A, and how to convert our ideas into patents. So Karma Yoga Institute of Technology is basically at a rural place, and students have good thought process. Only the kind of pushing is required to convert their ideas in such outcomes like IPR. So definitely after completion of the session from Bidwai madam, our faculty members as well as students will get motivation for publishing and granting the patents. So on occasion of world, I congratulate opportunity to all the faculty as well as students to have interaction, such a great interaction with Professor Saili Bidwai madam. So instead of wasting much of time, I request Professor Saili Bidwai madam to take the charge and guide our students and faculty members in this regard. Over to you, madam. Thank you.
Thank you so much, sir. I hope my screen is visible.
Yes, ma'am.
I welcome you all for this session. I would be glad to share some of my insights related to intellectual property rights. And I wish at the end of this session, you might get some inputs which would be useful for everybody. We are going to discuss these things, like we'll start with why one should know about intellectual properties, then what exactly is the concept of IPs and what are the rights associated with that. Along with that, I'll be discussing even the types of intellectual properties which go through patents, copyrights, and trademarks. And then when we come almost at the end of the session, you will be able to see what is there in your hand. If you are a student, then what you could do in your capacity. If you are a faculty member, then what are the opportunities wherein you can manifest into some technological invention and how to earn out of it. Now, when I'm saying this, the earning part, it begins very well from the ideation. The very purpose of any intellectual property is ultimately earning, generating revenue. So this is the ultimate objective. This you should keep always in mind. Now, when we are speaking about why one should learn about it, So if we look at one glance, the ranking of India in the overall worldwide ranking, which was done in 2021, India stands far behind China and US. Now, you might have also seen in many news recently that right now China is ahead of US, and not only US, but overall, almost 85% of the patents filed last year worldwide, 85% of the patents are belonging to China. So I'm not promoting how China is bigger or how China is working, but we can take inspiration from that country who, in spite being overwhelming, what we can say, the population, it's not merely the number of population, people are creative as well at the same time. So if we have to beat this, not only in the number of population, but also in IPs, people like you and me should start thinking from solving small problems, taking up those problems, taking it ahead to ideation, then create its prototype, go ahead with innovations. Once you had innovations in any kind, please manifest it in the form of IPs, one or the other type of IP you will have. Once you have got the rights, then you can go for commercialization. So the journey starts from your mere thinking, and that too a kind of different and innovative thinking. So it's not only about India, we should start from ourselves. So let's see what exactly an IP is. The word property. So when in our day-to-day life, the word property is used to indicate any personal property, like having a land or a vehicle on your name or a flat on your name, and that property is considered to be your asset. In exactly the same way, intellectual property is also your own property. Now, if, for example, if I have some amount of gold, so that is my asset. And if I want to, encash it, so I just can go and sell that gold and get the equivalent amount of money. And now that money I can utilize for whatever needs I have. As that gold was on my name, I was owning it, then only I have the right to sell it. Exactly the same way, once you have your property as an IP, intellectual property, intellectual means which has come from your mind, which has come from your imagination, your ideation. So that kind of intellectual property also holds the similar rights, because of which you can earn money as and when you want. So anyway, we are going to see in what all ways we can utilize the IPs. But at first instant, we must understand it is one of the biggest and strongest tool for earning money. Nowadays, students strive and they are struggling in the rush of getting placed in different companies. Hardly the student, this I'm talking about the students hardly care about their projects, keeping an innovative idea in it. So we just I have seen students hunting just for shops from where they can buy projects and just dump it on the head of a guide, and that's all. So instead of this attitude, if we change it in such a way that take out a small problem, work on it, and then have an intellectual property over it. So once you create it, once you have its right, you also get an extended right of selling it, giving that IP on rent to somebody. So the typical word used in that context is licensing. You can license your technology which you have developed. So the whole notion goes behind wealth creation. So once you have created an intellectual property, a property which has come from your own mind, is in short called as an intellectual property. So once you have a property, now it will be your decision how to utilize it. So this is what the concept of IP as a whole is. Once we are saying property, there are some rules associated with that. There are some laws, acts related to it. Now, as there are different types of IPs, every type will have its own act, its own set of rules. Now, from where these IPs will come? It comes through inventions. It comes through literary and artistic work. It comes through creative symbols, names and images used in commercial world to indicate any name of a company, of a brand. We very easily identify brand of Nike with the help of what? Quickly tell me. How do we identify a brand of Nike? So I suppose all the participants are muted, so because of which nobody is able to unmute their mics and able to give answers. So it's just a
By symbol.
symbol of a tick, which once we see, we don't need to write Nike there. We understand, yes, that tick mark indicates that it is a specific brand. So what I mean to say is, any creation, let that be in the form of an invention in the form of a machine, or your program written for a software, or design of a critical component, let that be a literary work. Literary work may will include your research papers, or there could be some artistic work. So all these things, as they are the creations of human brain, they all come under one or the other type of an intellectual property. So as a whole, from this introduction, we understand the concept of IP is, it is just the creation of human mind, and we can utilize such a property exactly the way we utilize our own personal properties. Now we talked about IPs. Let's see what are the rights. So once I register an IP with my name, I will get a legal right to fetch benefits from that IP. So till I register, or if I don't register, obviously I don't get the rights. Or in other words, if I want the rights to sell or give it on license, I should first register that IP in an appropriate type with an appropriate mechanism. So then only we can avail the benefits of that right. So the legal protection of new creation actually encourages every creative thought of any individual to create few more concepts, few more ideas. See, if I have an idea of a flying machine wherein only a single person can sit, and it will be an automatic vehicle which would fly and take me to another place. So if this is my idea, even I manifest, if even I prepare, it's a prototype, but till I register legally on my name, I don't get its rights. Suppose I have a team working on the same project and somebody goes, if we have a dispute, my team member will go away and it will take the whole idea and create its own new prototype of a similar kind and registers before me. Okay, before I register it as a patent, if my teammate goes and does that, so the one who registers first will carry the rights. So it is very important that we have to protect our ideas till it gets registered, it gets connected to our name. But at the same time, it is encouraging all the creative minds that if I create something new, I will get its benefits. So obviously, if I'm getting benefit, everybody will get tempted to create new things. As it increases the economic wealth of an individual, the same happens with industries, small scale industries, big industries, and ultimately the country. So if we start from ourselves, eventually it is going to benefit the society and the country as a whole. How do we classify IPs? IPs are broadly classified into two categories: industrial property and copyright. Now there is one more thing called as trade secret, But this we don't take as a type of IP. It is altogether a different concept that will come at the end. So broadly, the intellectual properties are classified into two types. One is industrial property and another is copyright. So based on what we divide them, the creative ideas which can be printed, which can be copied, are called as copyright. Means we can prepare its copies, which comes on paper. That comes under copyright. And rest of the creative ideas which can be manifested in some or the other form, they are linked with industry. They are called as industrial property. Now we do have examples of industrial property, patent being the first one, which is given for inventions. Patent is a subtype of industrial property. Similar to that, trademarks are also considered as industrial property because we identify industries based on the trademark, or trademarks are used for the advertisement of industrial property or their goods. Then there are industrial designs. Industrial designs are nothing but the aesthetics of any product which is being manufactured in any industry. So again, it is linked with industry. So it comes under industrial property. And the last one is geographical indications. Usually natural or man-made products which are specifically linked with some geographical location can be protected as geographical indication. As there is an industry aspect linked to it, it goes in the industrial property. So for an example, Nagpur orange. Now Nagpur orange, though orange is a naturally, it is available in nature. Human beings cannot create them. But why it is linked with Nagpur? Because the aroma, the texture, the color, which we get, the taste of the oranges which are available only in Nagpur region have got some specific features and they are good. They are better than others. So Nagpur orange is it is actually registered as a geographical indication. Now this is naturally available ingredient. Now Kashmir shawls. So the shawls being woven in Kashmir region, it is also a geographical indication. So either it is man-made or natural, but they have some specific properties which you will never find in any other geographical regions. So we call that kind of IP as geographical indication. So as we know, broadly we have divided the IPs into industrial property and copyrights. Now let us see in detail what are copyrights. As I mentioned, which can come on paper, which we can print, which we can Xerox, which we can prepare copies of, are called as copyrights. So what comes into that? Novels, poems, plays. So we can have our own novels. We can write some research papers. We can have books out of it. Then there could be films, because there are writers of a movie. There is a music which can be composed and it can be written on paper in some specific language. Then some artistic work like drawings, paintings, and photographs, they also can come under copyright because they are all creations of human brain. And then architectural designs of buildings. Now, these are the things. In addition to that, we do have rights related to performing artists and their producers of phonograms. So suppose there is a movie. We have big cases going on of piracy of CDs and DVDs. I mean, in earlier days, when they were invented, they were in bulk in the market. Then the copyright cases used to be there a lot. There used to be raids in the shops which used to sell the pirated CDs and DVDs of movies or movie songs. Maybe in your childhood, you might have seen that. So why they were banned? Because the rights of copying such CDs and DVDs belong to the producers of such movies. So that is the reason producer invests into it. So producers will carry all the rights on such recordings, and without taking his consent, if somebody is selling just by pirating it, so obviously it's an offense, and there are strict punishments by the government. Then comes trade secret. Now, trade secret we don't count as a type of IP, but it itself is an intellectual property. Trade secret means, for example, recipe of Coca-Cola. So Coca-Cola is a beverage, a cold drink, which will have some method of preparation, but nobody will give you, or on YouTube, you won't find its preparation, method, isn't it? You will find many recipes on YouTube, but you will never find the branded beverages or food items recipes. So they are kept secret, and that is their core value based on which their businesses are running. So though we have those businesses, still they don't disclose their procedures, and that is the reason they are called trade secrets. Those have to be kept secret, but they are creating money out of it. So there is no procedure of filing a trade secret as such, because as I mentioned, they are kept secrets. Now let us see each IP in detail. First, let us take patents, because patent is considered to be even a biggest asset of a country for the evaluation of how much wealth a country owns. It includes patents. If we have to even evaluate how much wealth a company or an industry has, that also has the major role of patents to play in that asset. That's why we are taking patents initially. So for what things we can apply for patents? So we apply for patents for inventions. Now, what do we mean by invention? Invention could be a chemical process which could lead to creation of some medicine or a drug. So that also could be invention. Invention could be a machine. Invention could be a computer program. Of course, in India, we don't give a computer program to be protected under patents. For that, we have copyrights. But yes, in outside countries, for example, US allows computer programs to be, filed as patents for softwares, particularly. So invention could be in any form. It could be an electronic gadget. It could be a machine. It could be chemical reaction, or like a medicine. So these many things will cover under inventions. Now, how to file a patent? So we actually have to apply by filing an application and then writing, filing an examination form as well. So there is a procedure which is available online now, either individually or through some patent agents, you can file a patent. So the procedure is by applying through an written application. Once an application is filed for an invention, from the date of filing, we get 20 years of protection for that invention from the date of filing. Now, no matter when it gets granted, usually a period of 3 to 6 years is required for granting a patent. But from the date of filing itself, you get the term of 20 years. In case of copyrights, what can be copyrighted? Literary or artistic work. Literary means anything that you write in the form of a book, research papers, novel, poems, literary. And artistic, paintings, drawings, sculptures, or architectural designs. So these all come under the same category of copyright. So if you have anything innovative in this form, which has never existed before, literary or artistic, so that can be, once you prepare it, like once I write a book, that becomes my copyright. I mean, it exists automatically. The rights exist automatically the moment I create it. But if I want legal protection, if I want legal actions to be taken, if somebody is copying without my consent, then we have to register. Again, there is a process online which is available. And in general, there are again different types as whether the work is a literary work or artistic work. Accordingly, there will be slight variations in the period for which protection is given. But in general, lifetime of the creator plus 60 years after death. Usually, on an average, this much time protection will be provided by the government. Because we have registered it. If we don't register and we just create it, it will be with us till it is there. If somebody steals it or copies it, we cannot claim anything. Let us come to trademarks. Trademark basically is a symbol or a combination of numbers, names, pictures, and specific colors which are indicative to a specific industry. As an example, I gave you Nike. The same applies to any other brand. Let's say Bisleri. So we are so used to with this name, Bisleri, that even though there are multiple vendors being there in the market for distilled water, drinking water, still we call every distilled water bottle as Bisleri only. So it has become like a bottle means Bisleri. I mean, a bottle of drinking water, distilled water is Bisleri. So when I'm giving you this example, that the trademark has become so famous that we don't even read the name which is written on that bottle, on the label of a bottle. We don't even care about how exactly the shape is. But all these things related to a brand is, let that be a design of a bottle or the color and alphabets and the font which is used to indicate the name of the brand. So that all is protected in one or other IP. So trademark is something which is a distinctive identification of the product or a service. Now, product we understood, Bisleri is a distilled water bottle. So that is a product. Now, what about service? If we see a keyhole, so that indicates it is a symbol of a bank. So usually you might have seen the keyhole inside a circle that with a light blue color. So that itself indicates the service which is being offered by the national banks. Let that be any bank. Now, Bank of Hyderabad also will show the same keyhole. State Bank of India also will show the same keyhole. So what we understand from these, symbols, it is the service. So I'm not saying all these are trademarks, but yes, these are the indications, indicative features, distinctive features by looking at which we understand what kind of product it is, what kind of services that particular company is giving us. So what we can protect under trademark? We can protect under trademark any word, symbol, combination of words and alphabets in a specific color, in a specific brand, and sometimes the sound, tunes. The tune of Britannia, if you can recall, the tune of Britannia is a trademark. It's actually a musical note, but it is indicative of the business. So though it is an artistic work, but as it is used for trading purpose, that tune is treated as a trademark. So trademark can involve not only the pictures and images and logos, but also sometimes like this, a musical tune. How to file a trademark? So if I start using a particular symbol without registering, since then it becomes my trademark. But if I want anybody else, if I don't want anybody else to copy it without my consent, then I have to register. So there is a process online available with the support of some documents by which we can file a trademark. So either use or registration, both will support. Now, once registered, we will get a term of 10 years for trademarks, and it is extendable by paying an additional amount of fees before the expiry of 10 years. If I file that I want extension, then it can be extended as well. Next IP is industrial design. Now, when I was talking about Bisleri bottle, I told that the shape of that bottle also matters. Nobody can copy the shape of Bisleri bottle, though it is for any other beverage, not only the distilled drinking water, but also the aesthetic look, the appearance of that bottle. It means the grooves which are formed on the surface of that bottle are also calculated. They are not just random wavy structure. It is calculated. The length and width and texture of the label which we put, the color which the cap is having, the color which the label is having, everything comes under industrial design. Why industrial design? Because the external appearance of the bottle is indicative to that particular industry and that particular product. So the industrial designs also have to be registered by applying through an application online. And once it is filed, from the date of filing, we get the term of 15 years. So you might think, what after 15 years? Or in case of patents, what after 20 years? That we'll talk. And last one is the trade secret. Trade secret, as I mentioned, there is no procedure of filing because we don't file it. Filing means we are disclosing it. And secret is we should never disclose to anybody. So when it is a trade secret, the whole trade, whole business depends on the secret. So we have to keep it secret. So whatever valuable information about the trade, we have to keep it secret. So we don't have to disclose it in public in any way. And how to protect the trade secret? By reasonable efforts, by keeping it a secret. That is the only way. And as we are not going to register it, as we are not going to disclose it to any authority, then there is no limit for which the protection is being given. So it's like, till you can keep it secret, it is yours. Once it is disclosed, it is gone. Now I was talking about what after the term. I'll take example of a patent. Once the term of a patent expires, it goes into public and anybody can work that patent for their own industry. Now I'll give you one of the examples. You might have seen the medicine shops of generic medicines. Now, what exactly is that generic medicine? Usually when the medicines are prepared, the pharmaceutical industries take patents on it. So once they apply, from the date of application, they get the term of 20 years. So they can avail their monopoly rights for 20 years. They can give extension also. But after the expiry of 20 years, anyway, when they are applying, they are providing all the information, starting from the setup, the process, timings, particulars, and everything which is required for the preparation of that particular medicine is disclosed to the patent office. It is then published in the public domain. So anyway, once you file a patent, it is already available in the public domain, but you are not allowed to use it till you get consent of the patentee or the applicant. That kind of protection the government is giving us by the virtue of filing that patent. That is the benefit. Now, after the expiry of the term, that as the knowledge was there already in the public domain, any other pharmaceutical company can take that knowledge and start manufacturing the drug. And once the rights are over, the monopoly rights are done. So the patentee cannot withhold other parties from manufacturing it. So there is no penalty, there is no cost for taking that know-how, and they can easily manufacture it. So obviously the cost of production After the period of after the expiration of the patent period, it becomes easier or cheaper for manufacturing, and hence the such type of drugs will be available cheap in the market. So there is no question on the quality, but the production cost reduces as the term is expired. So that is the secret of generic medicine being very cheap than the normal ongoing products. So this is at glance, we are observing what kind of creative work can be protected under what kind of IP and what amount of period will be given as protection. Now let us take patents in detail. It's an exclusive right granted for an invention. Exclusive means the person who is filing a patent has got all the rights, and without his permission, nobody else is allowed to use that technology for their benefit. It could be a product. The invention could be in the form of a product or a process, which actually comes from a problem. So that is the reason I was insisting initially that when students are choosing projects, they should not choose a project ideally. They should choose a problem statement which is unsolved. And by providing the solution to such a problem, obviously leads to some kind of invention. And once you have invention, let that be in the form of a product or a process, you have got all the rights to protect it under a patent. A patent could be an electronic system, it could be a mechanical machine, it could be a software product, it could be a medicine, or it could be a combination of electronic system embedded into a mechanical machine, a software driving that complete machine automatically. It could be anything. So just for example, to separate out the technological domains, I have given like electronic system. But for preparation or packaging of that electronic system, we obviously need some mechanical engineers for creating its packaging. So we cannot isolate one technology from other, but the invention, the core invention lies in the electronic system. So this is how patents can be done. Then designs. Usually in layman language, we call it as design patent, but ideally its name is industrial design. Industrial design is the legal protection of unique visual qualities, the aesthetic qualities of a manufactured good. So first of all, that item has been manufactured from industry and it is having some aesthetic qualities, some particular qualities. For example, I gave the Bisleri bottle. It could be even an ornament which can be protected under industrial design because that has come from some industry. So that is an outcome of an industry. And also it is having some specific visual features. So that could be industrial design. Then there is a notion called process patent. Usually for the manufacturing of medicines or drugs, there are some specific chemical reactions, some specific treatments are being given to particular chemicals. So in that case, the process could be innovative. The material or the components which are used in that process could be, routine. But because of the innovative process, the drug can have different qualities. And that is the reason we do also file some patents which are based on the method of preparation. So we don't have a specific terminology called as process patent, but yes, the process is actually coming in the claims, and because of which we can call it as process patent. So this is the overview of patents, and these are the examples. You can see this bottle is of a particular cold drink. Now you can identify this leads to a design. Okay, the design of goggle, the design of sandal, but there is a process patent involved in the medicines. And if we look at the car, it is a huge combination of multiple IPs. The logo which we put on in front of the car will be a trademark. The shape and size of particular color of the alphabets which are used, or some specific symbols used to indicate the manufacturing company, that is a trademark. Then there will be some electronic systems installed, embedded inside the dashboard of the car, which would be controlling many of the operations in it. So that would involve multiple patents. The shape, the car having a rooftop and without roof. So the shape can be filed as what we can say industrial design. So we can say a car or a mobile phone or a laptop is a combination of multiple IPs. It will have number of intellectual properties all together integrated in a same package. The concept of patent I already discussed. It lies on an act, the Patents Act 1970. Why we write the year 1970s? From then, India has started adopting the act. Then let us look at industrial designs. Industrial design is what? The visual qualities of manufactured item are protected under industrial design. So design patents provide actually the protection for ornamental, look of any manufactured good. Now, how to decide if you have some idea, or if you might have even developed some prototype, then how to decide whether it is patentable or not? See, there could be numerous inventions, but all of them cannot be patented. It is a tricky sentence. There could be inventions, there could be discoveries, but all of them will not be eligible to be patented. So there are sections actually in Patents Act 1970, the whole section 3 and 4 talks about what cannot be patented. For example, a method of treatment. The doctors use some particular methods of treatment that cannot be patented. Though that method is innovative, only that doctor knows it very well, but we cannot patent that process. Then we cannot, there can be inventions related to atomic energy. For example, an atom bomb. That is also an invention, but as it is destructive to human life, it is a threat to human life. So such inventions, though they are being inventions, we cannot file patent. In India, it is banned. So how to decide then? There are some constraints. So if you have any idea and if you want to decide whether it is patentable or not, there are 3 criteria. That invention has to be novel. Novel means it was not existing earlier. It never existed. Now it is completely new. That is novelty. Then inventive step. It should not be a routine process for the people skilled in that art. It's like, suppose I am an electronics engineer and I prepare a beautiful machine. I feel like I have invented a machine. But for a mechanical engineer, that could be a routine work. That is no way an invention. So inventive step should be involved into it. That is second criteria. Third is industrial applicability. When I have an invention, either it could be manufactured or it could be used in the manufacturing process. So some or other way it should be linked with industry. Then only that invention can be patented. So there are 3 criteria: novelty, inventive step, and industrial applicability. If your invention qualifies all 3, then only think of filing a patent. Just don't do it for the sake of publishing it, because papers are published. Patents are utilized. Patents are used. So we are not publishing patents. Ideally, we should not do that. Okay. Then we can also have some improvements over the existing patents. So there is one way of going for an invention. Either if you take an open-ended problem statement, work on that and come up with an innovative solution, still it will lead you to a patentable invention. Or if you study some existing technology, already patented stuff, if you study well, and if you find that now there could be a significant improvement done into it, then still you can file a patent. So not necessarily you have to build a big project and then only a patent could be done. No, for a simple idea also you will get a patent. So as I mentioned, we have a patent law system existing since many years, but it came into existence in independent India since 1970. There is an exhaustive process involved. There are 4 offices. Earlier, we used to have hard copy filing, I mean, offline filing of a patent, but now it is online. So we don't have to go anywhere. We can just explore this website, which is given at the bottom, and we'll get all the information required for filing a patent. So these are the steps involved in filing, along with the timelines. So from 3 years to 6 years maximum in India, it takes for granting a patent from date of filing. And once granted, you will get such a certificate. Now let us talk about another intellectual property as copyrights. You might have seen this symbol, which is shown in the bottom. So this symbol comes as a copyright. Now you might have seen even the same symbol at the bottom of each of my slides in this PPT. So that tells that without my permission, nobody is allowed to copy it. If I permit, that is okay. Copyright is what? The rights given to the creator for their literary and artistic work. That's what a copyright is. And you will see such symbols even in softwares. If you open any website, at the bottom, you will find some information related to its copyrights. Even if you open any book, in first few pages, you will find this symbol mentioning the copyrights. So the literary works such as novels, poems, technical books, research papers, all can come under copyrights. The artistic works such as paintings, drawings, musical tunes, live performances, then computer programs, databases, movies, everything comes under copyright. And there are very strict procedures for infringement. Infringement means breaching the law. Copying anything out of it, out of all the examples which have been given as copyrights. So if we take anything without permission, it will be a serious offense. Infringement, as I mentioned. There is an act called as Copyright Act 1957. The way Patents Act 1970 came into existence or we have amended everything in 1970. Similarly, Copyright Act is done in 1957. So that year comes always along with the name of this act. It has all civil remedies, criminal remedies. What if an infringement case happens, then what are its solutions? What are the processes to be followed is listed in this act. Then we have trademark as another intellectual property. A trademark is something which comes as a symbol. So we can say, like, when we see this symbol TM under a circle, it means we have filed a trademark. Okay? When it is R inside a circle, it is already registered. The rights have been already taken. It is the meaning of it. Still, it is a trademark. And then SM is the service mark. If we are not giving any product, if the industry, a particular industry is not having any product, but it is having services, so it comes under service mark. So trademark basically is a distinctive sign that identifies certain goods or services produced or provided by an individual or a company. It can be one or a combination of words, letters, numerals, or it can be also consisting of some drawings, symbols, use of specific colors. It could be three-dimensional signs also. Trademark is also based on an act that is called Trademarks Act 1990. Now, here are some examples of some trademarks. You will find TM written above Google. It means they are into the process. I mean, they are using this trademark. Intel has got R in circle. So R means it is already registered. IBM has got R. Then McDonald's has got R. Dr. Reddy's has got nothing, but they are using this symbol to indicate their services. That is a what pharmaceutical company. Then Bharat Forge, Kalyani, they have been using this symbol for their businesses. So these are well-known marks, though they are not registered, though they are not, granted registration, but still, as they are using, it is their indication. So they are also called as well-known marks. There are total 34 classes for goods in the trademark for different products, and 11 trademarks, 11 classes for the service marks. Now let us talk quickly about geographical indications. There are 3 examples. Darjeeling tea, the tea which is grown in Darjeeling region. Kashmiri shawl, so the shawls which are woven in Kashmir region. And Nagpur oranges, the oranges which are grown in Nagpur. So it is actually a sign used on goods that have a specific geographical origin. So as I told you, either it is naturally grown or man-made. But if it comes only from a specific geographical region, we can file a geographical indication. Usually an organization or a community can file a geographical indication. There are some success stories to share. There is a company called Green Soul. So they are into manufacturing slippers from used footwear. Now that footwear could be shoes or sandals or chappals. But what they do, they literally collect from dump yards the used footwear. They clean it, polish it, they design their own designs of slippers and they sell it. Now Green Soul is, you can see a small letter R in the circle. That indicates it is a registered trademark. So why I'm telling you this is, the idea is usually the founders of this company were the marathon running people. They were the sportsmen. So what they have seen, once the sole is used, that sole becomes, flat, and it is not ideal for an athlete to use it while running. So just because the sole is flat and the grooves have been removed, we cannot say that it is completely useless. But still, such athletes literally throw such shoes in garbage. Looking at the situation at one end in the country, that there are hundreds of people, kids, who are walking barefoot. They don't even have anything to wear. So this company Green Soul took this as a problem, an open-ended problem. At one end, there are people with shoes, they are just throwing just like that. And at another end, there is a huge public which do not even have anything to wear in their foot. So that unsolved problem is taken and they have started creating such chappals. So their goods are having patent on it. The process of creating slippers out of used shoes. That is their problem statement, and they have solved it. This is one story. Another is youngest patent holder on a wheelchair. A physically disabled kid has created, as he used to be lonely at home, he has created a chessboard which can be played by multiple people. Let's say 6 people. We know a chessboard which can be played only between 2 people, but he has created the design. Now he has got a patent on that creation. So what he thought of, he had a problem of loneliness, and how he had overcome by creating a game itself, and which could be played with 6 players at once. There is one more very old success story. See, this girl called Ankita, she used to help her father in a shop of Xerox. I mean, with a poor economic background, she used to help her father. And when she realized she used to staple the Xerox bundles of paper, she used to staple. But eventually she thought like she could not realize when the stapler pins was over. So there used to be one moment when the pins used to stop coming from the cartridge. Then what idea she did? She started using a nail polish, and she used to paint the last few pins with red nail polish. And the moment she used to see red pins, then she used to understand. Now the cartridge needs to be replaced. So this was a very, very simple idea of painting last 10 pins in the cartridge of a stapler. And a patent was filed. When she was in 10th standard, it was awarded to her. So this is what I wanted to emphasize. It's not always a very hi-fi technology wherein you have to work and very big invention you have to make, for which you need a laboratory, funding, this and that. There could be a small idea, but you have to work skillfully and you will be able to achieve great outcomes from it. So if there are any researchers or faculty members, I can suggest them that you can invest your time in thinking on some open-ended problems. You can solve those problems with your innovative thoughts. And once there is something in hand, something tangible in hand, that could be manifested as a patent. Another thing, what you can have, the thesis, like MTech thesis or your PhD thesis, could be copyrighted as a book or monograms. So ultimately, you will have some IP on your name. So that way, individually, you as an individual or where the organization where you're working, ultimately both will be benefited from your IPs. Then for students, for engineering, pharmacy, or any science or technology background students can think upon taking the help of technology in solving the problems. Again, we have to start ultimately from an unsolved problem itself. But you can take help of technology. And the very good tool to involve any kind of technology is your projects. Let that be a mini project, minor project, major project, let that be any kind of project. You can build a project completely based on some such problem statements which could be readily used in industry. Then for industries, for startups, startups are given a specific right which patents, I mean, if a startup files a patent, it will get a special treatment. It can be expedited. The fees charges are equivalent to any normal human being. If you compare the charges or the fees paid by startups and big established companies, there is a huge difference between the fees. Government fees I'm talking about. If you are an institute, as an institute, the number of patents filed, the number of copyrights you have will boost the NIRF ranking, ARIA ranking, the ATAL ranking, which we talk about. It will have a separate weightage in NBA, NAC, and whatnot. And ultimately, once having these many IPs on our name, if we start, creating wealth from it. In the very beginning, I told the sole purpose of any intellectual property is creating wealth. It's not merely for publishing. It's not merely for showcasing. See, I have these many patents on name. No, till you commercialize it, it has no meaning. Whatever number of IPs you own on your name. But till you commercialize, it has no meaning. And hence, once you have multiple IPs as an institute, as an individual, as an organization, you can create, a different impression in the society. Having wealth, no, who will not want having wealth? As a country, we want to be richer. As an individual, we want to be richer. So ultimately, we can utilize our own skills in building our own technology and create wealth from it. I'm showcasing some important websites which you can refer. These are open resources which you can, refer for your own knowledge enhancement. And that is all. Thank you so much. If you have any queries, either you can put them in chat box, or if your mics are open, you are welcome to share your queries. There, I can see some questions. One question is, what is lifetime plus 60-year means? Lifetime is if I am a creator of any copyrighted work. If I write a book, so till I'm alive, I can avail the benefits. At whatever time I die, after that 60 years, the assignee, to whomever I assign my rights, will get benefits. So this is the meaning of lifetime plus 60 years. Lifetime means lifetime of the creator of that work. The second question is, can we extend period of patent? Yes, we can extend. There is a specific fees, and even there is a limitation on how much period and how many times we can extend it. We can extend, but it's not infinite. So if you have any other questions, please go ahead. If it is done.
Is anyone having question?
Can anyone respond me?
So thank you for your valuable guidance, Saili ma'am. Now I request to RJ Bhosle sir for vote of thanks. Yes, sir.
Sorry, I was not able to hear you. There was a phone call.
Hello, I'm audible.
Yes.
Okay, now it's time for vote of thanks. So on behalf of Carnegie Institute of Technology, Sheve, Pandharpur, I would like to thank Professor Saili Madam for accepting our invitation within very short time period and giving valuable guidance on intellectual property rights to our staff members and students. I also thanks to our chairman, Honorable Rohan Malak, and our principal, Dr. S.P. Padil sir, for giving permission to conduct such useful webinar. Now, with the permission of dignitaries, I declare today's program is over. Thank you.